Get ready. Scope of Section 106 of the Indian Evidence Act was examined in considerable detail by the Apex Court in the case of Sambhunath Mehra versus State of Ajmer, reported in AIR 1956 SC 404, wherein learned judges spell out the legal principle in paragraph 11, which read as under semicolon. This lays down the general rule that in a criminal case, the burden of proof is on the prosecution, and Section 106 is certainly not intended to relieve it of that duty. On the contrary, it is designed to meet certain exceptional cases in which it would be impossible, or at any rate disproportionately difficult for the prosecution to establish facts which are especially within the knowledge of the accused and which he could prove without difficulty or inconvenience. The word especially stresses that it means facts that are preeminently or exceptionally within his knowledge. In Rajik Ram versus Chauhan, reported in AIR 1975 SC 667, it has been held as under semicolon. 116. In the first place, it may be remembered that the principle underlying Section 106 Evidence Act, which is an exception to the general rule governing burden of proof, applies only to such matters of defense which are supposed to be especially within the knowledge of the defendant respondent. It cannot apply when the fact is such as to be capable of being known also by persons other than the respondent. In a state of West Bengal versus Mir Mohammad Umar, reported in 2000 SCC CR 1516, it has been reiterated as under semicolon. In this context, we may profitably utilize the legal principle embodied in Section 106 of the Evidence Act, which reads as follows: when any fact is especially within the knowledge of any person, the burden of providing that fact is upon him. The section is not intended to relieve the prosecution of its burden to prove the guilt of the accused beyond reasonable doubt. But the section would apply to cases where the prosecution has succeeded in proving facts from which a reasonable inference can be drawn regarding the existence of certain other facts, unless the accused, by virtue of his special knowledge regarding such facts, failed to offer any explanation which might drive the court to draw a different inference. Vivian Bose, J. had observed that Section 106 of the Evidence Act is designed to meet certain exceptional cases in which it would be impossible for the prosecution to establish certain facts which are particularly within the knowledge of the accused. The applicability of Section 106 of the Indian Evidence Act, 1872 has been loosely explained by the Apex Court in paragraph 23 of its judgment rendered in the case of State of Rajasthan versus Kashi Ram, reported in JT 2006 12 SCC 254, which runs as here under सेमी।
अगर तुम लोग नए हो तो सब्सक्राइब करो, वो जो लाल वाला बटन है उसके साथ सूर्य नमस्कार करो या फिर अनुलोम विलोम, मुझे नहीं पता, बस क्लिक हो जाना चाहिए।